And I would like to invite Professor Gábor Hulkó from the Széchenyi István University and Ferenc Mádl Institute of Comparative Law to present some short remarks.
Thank you very much. I will try to be very short and on the point with my presentation. Today I would like to follow up on Katka's presentation on the symbols of municipalities with another form of not state symbols but the symbols of national minorities in the Czech Republic, their use and their legal protection. And as it is a co-referendum, I would like to put on the place more questions than answers, to raise more questions than answers, as it is quite an unregulated area of the legal system or the Czech legal system, as there is no particular regulation concerning the use of the symbols of national minorities. However, there are several questions how these symbols should be used, or what are the baselines, what are the basic principles which should be accepted and should be respected in this matter. So I would like to enhance and a little bit broaden the scope of the previous presentation. And you may ask that what am I going to talk about if there is no regulation on this matter? Well, there is no special regulation, but there are some baselines or there are some principles of the regulation which can be considered as a solid basis for the use of the symbols for national minorities in this regard. If we are looking at the general regulation or general level of the regulation, we could consider the constitutional level, of course. At the constitutional level, there are basically two rules which are very important in the context of the Czech regulation or the Czech Republic. The first one is a statement from the European Court of Human Rights, which is also respected by the constitutional order of the Czech Republic, which says that there is a consensus among the contracting states of the Council of Europe that the special needs of minorities and the obligation to protect their security, identity, and way of life should be recognized, not only to protect the interests of the minorities themselves, but also to preserve cultural diversity that benefits society as a whole. So this is one of the baselines, this is one of the basic principles of the regulation, which I wanted to cite to be precise on this matter. And also there are the rules of the Constitution which are not dealing with the symbols of national minorities, but are dealing with the protection of national minorities in the Czech Republic in general. What does the Constitution say to us? The right to a free choice of nationality represents, on one hand, the negative obligation of the Czech state. That means that the Czech state, the public authorities, are to respect the choice of the individual, not interfere with it, and of course the state is prohibited to carry out targeted nationalization, for example in the form of pressure on individuals not to declare their nationality, or preventing them for observing cultural or linguistic tradition, or using symbols or signs associated with their nationality. That is one very important part, that there is a negative obligation towards the state, what the state should not do. And there is a counterpart to this negative obligation. That means that there is the part where it is stated what the state should do, and the state should and has the obligation to protect individuals of national minorities from possible coercion, influence, or their free decision by other private persons. So there is this negative and there is this positive aspect of the regulation, if I might add, and this is the baseline of the regulation, or baseline of the protection, or the regulation, the non-existent regulation of symbols, of use of symbols. So in this way we are basically. In this way, we basically know what is the regulation. The second question is, what are we regulating? Who are or what are the national minorities in the Czech Republic? At the 2021 census, there are the following national minorities living in the Czech Republic. There are Slovaks, Ukrainians, Polish, Vietnamese, German, Russian, and the Roma nationalities. And if we are taking a look on our subject of our regulation, that who are we regulating or what are we regulating. This raises, if we look at the enumeration of these national minorities, we can see two dimensions of these questions. Because one part of the national minorities, that means Slovaks, for instance, Ukrainian, Polish, or Vietnamese, or Germans, they have their home states. Yes, they have their home state symbols. So this is one dimension or one level of the regulation. That how should we regulate the use of other states, or in this case the home state symbols of these nationalities? And of course there is a large population of Roma people, Roma nationalities, who or which are using the symbols of true national minorities, as they do not have a home state. And this is the second part or second question, if we should consider talking about a regulation. But as I told to you, as I explained to you, there is no special regulation according to this matter. If we are looking at the home state symbols or the home symbols of the nationalities, which are basically everyone else except of the Roma nationalities, Roma minority, the use of foreign state symbols is not regulated also in the Czech Republic. There is a question, however, because there is the regulation on the state symbols of the Czech Republic. There is a statute, a law which regulates the use of the state symbols of the Czech Republic if it can be used per analogiam, so analogically for other state symbols. But here the Constitutional Court and also the Supreme Courts of the Czech Republic stated that it is not possible. It is in the case of the analogical use or the use of the reasoning per analogiam, we should be approach this model very, very carefully in the case of public law, especially in the case of state symbols. So there is basically no legal gap. And this legal gap, according to the Czech judiciary, legal gap is absolutely needed to use the per analogiam method in the field of public law. And as the regulation on the state symbols of the Czech Republic expresses verbis explicitly states that it is a regulation of the symbols of the Czech Republic, it cannot be used for other state symbols. It is quite logical argumentation from the courts. But the use of the symbols of other states is not illegal in the Czech Republic, and I think, from my personal opinion, that also that the Czech society is quite benevolent in this manner. So this does not cause, or this is not a cause for any real problem or any real conflict. The other thing is the symbols of national minorities, which means that they can use, especially it is the case of the Roma minority, they can use special symbols which are different from other state symbols and which should be used in a proper manner. Also, if we look at the judicial opinions, we can define three very important principles when using these symbols of national minorities, or these true symbols of national minorities. One is the principle of legality, of course, that the use of such symbol should not violate other rules which are obligatory in the Czech Republic. So the principle of legality is the first one. The second one is the principle of proper use. That means that the abuse of such symbols is prohibited and also sanctioned by administrative offenses, administrative sanctions, or if it is high in social damage it can be also protected by criminal law. And the third, so this is the principle of proper use. And the third principle is the principle of dignity. That means that the use of the national, the use of the symbols of national minorities should be appropriate and dignified. So this is more or less. Sorry. This is more or less the basic rule set which can be considered as a basis for the regulation, but these are very, very abstract rules. and there is also, or can be considered, these abstract rules can be considered also a part of the protection of the minorities in general. So there is no special protection for these symbols, but these things should be respected, which I was talking about. And if we are talking about protection, there are several levels of this protection, which I'm not going to go into detail, based on two reasons. Time is the first one, and the second one is that Katka also informed us very much about the protection. There is a constitutional level, or the constitutional protection. There is the level of administrative law protection, liability, administrative offenses and sanctions, and also if there is a high degree of social harm or great damage, there is the protection on the level of the criminal law. So these three levels of protection are there. So to sum it up and to finish my presentation, there is one basic question which I want to address, that whether it is needed a new regulation or a special regulation for this matter in the Czech Republic. I have to admit that I'm not a very big fan of more regulation only for the sake of more regulation. So to create more rules just to have more rules, because, well, it is fine to have the students on exams, of course. We can teach them new things, but it is not the point of the legal system, the legal order. We should create rules only in case that there are relevant social circumstances to create for the creation of these rules. So I think that I would say that in this matter, the Czech regulation, which means basically no regulation, only these basic principles which I was talking about, is more than enough in the Czech Republic at the current state. And once more, I would like to say that it is the question of the benevolence and acceptance from the major population or majority of population, and I think that in the Czech Republic are living quite civilized people to accept this the use of national minorities, and if not, there is the way not of more regulation but more education, but I think that this is not the way of the Czech Republic. Thank you very much for your attention.